hear you. The Honorable Chief Justice and Justice of the Supreme Court of the State of Michigan. All persons having business in this court are admonished to draw nigh and give attention. The court is now sitting. God save the United States, the State of Michigan, and this honorable court.
We call the State of McLain and Lansing Fire Department.
Good afternoon, Your Honors. John Bursch on behalf of the McLain Estate. I intend to reserve 3 minutes for rebuttal, and I'll manage my own time. May it please the Court, I want to jump right in on the evidentiary question and demonstrate to you that these medical records are admissible, and we don't even have to get to an 803 sub 4 medical diagnosis analysis in order to have those be admissible. As defendants acknowledged in their brief in opposition on page 22, hospital records are generally admissible under the business records exception. And Michigan is kind of unique in this respect because unlike the federal analog for the business record exception, Michigan's rule specifically includes diagnoses as one of the things that qualifies as a business record. And the best explication of how this is supposed to work when it comes to the hearsay statements within that record is, of course, this Court's 1998 decision in Merrow, M-E-R-R-O-W. And the key to this case and understanding it is in footnote 8 of the opinion. And the Court says that the exception for records of regularly conducted activity can itself justify admission of a hearsay statement contained in a business record, but only where the source of the statement is acting within the course of business. So the foundation that you have to establish is that the source of the statement was acting in the regular course of business. And then the footnote goes on to criticize the dissent for saying that, well, in their view, we're saying the entire record is out. That's not what we're doing. They say in most of the document, the declarant is the physician. And as long as it's the physician, that's okay. In those portions of the document where the declarant is the patient, that's when you need some other justification to get the document in. So if it's a physician statement in a business record, it's automatically in. If it's someone else, then you have to look for an exception. So then the next question is, how do we know that the statements in these 3 medical records came from a physician? And I would ask you to just consider what the quotes are and use the Michigan Rule of Evidence 104A standard for admissibility. It's a preponderance of evidence standard, and the Court can look at anything that's admissible or not admissible to determine a threshold question of admissibility. The first note is posts. This is Exhibit G, the first page. He says, on presentation to the emergency department, it was discovered the endotracheal tube was in the esophagus. Is it more likely than not that that came from the family or the doctor? The second one is Exhibit H, first page. The tube found to be in esophagus, estimation 5 minutes. Is that more likely than not from the family or the doctor? Finally, and this is the kicker, the Henny note. This is Exhibit I, first page. Quote, there were not good breath sounds and the larynx was visualized with laryngoscope. ET tube seen in esophagus and immediately removed. Is it more likely than not that the family saw the tube in the wrong place and removed it, or is it more likely that the doctor did that? If you conclude it's the latter, then under Merrow and the evidentiary rule, 803 sub 6, then these notes are admissible. And you don't even have to consider any other foundational knowledge for those statements. In fact, the Sixth Circuit has said in U.S. versus Reese that the business record rule doesn't have a personal knowledge requirement for the records custodian. And the Seventh Circuit said in U.S. versus Keplinger that the qualified witness doesn't even need to know who actually recorded the information. So long as you've got a business record and you're assured that the statements in it are being made by someone in the regular course of their business, which doctors undeniably do, then these records are admissible, plain and simple. And so then the question becomes, getting the records in, is that enough to get us over the gross negligence threshold? And really, there shouldn't be a huge controversy over this because poor Ms. McLain, when she was first met by the EMTs at her house, had a blood oxygen level of 85%, which is already putting her at a risk for brain damage. The vitals of Ms. McLain were not taken again until she arrived at the emergency room, where the vitals showed that her oxygen concentration was down into the mid-40s. At that point, brain damage has already set in. And in those intervening 12 minutes, No additional vitals were taken. Now, I want you to consider how easy it is to measure something like the oxygen content of blood or pulse, which is directly related to whether someone is breathing or not, because she did not have a pulse when she arrived. If the tracheotomy had been successful, her heart would have started beating. You've probably all seen those little things that the doctors stick on your kid's finger that measures pulse and oxygen levels. It's called an oximeter. They had one on site. That's how they got her pulse and got her oxygen content, and never used it again, at least according to the only record that we have, the only evidence of what happened during that trip, during that entire 12 minutes. Now, their speculation is that maybe the tracheotomy was successful, and so her oxygen levels immediately rebounded. Of course, that would have restarted her heart, and that didn't happen, so we know that can't be true. But then maybe it was just when they were unloading her from the ambulance and taking her into the ER, that it was in those last few possible seconds that somehow her oxygen dropped from what would have been a normal level, 98 to 100, all the way down to the mid-40s. On a summary disposition motion, where the defense has filed and all inferences are drawn in our favor, you don't have to suspend the laws of science and assume that that's what happened, because that is not how blood oxygen in the blood works.
Let's assume negligence.
What's that?
Let's just assume negligence.
Well, there's clearly negligence.
Okay, well that...
So is anytime there's a failed intubation that doesn't get caught before transfer to the hospital, is that now going to be gross negligence?
No, I don't think so. I think it's got to be fact-specific. The standard, as you've said, conduct so reckless as to demonstrate a substantial lack of concern for whether an injury results. When you put a tube in somebody's throat or esophagus that they don't know where it is, and you don't, negligently.
Well, you're not intentionally putting it in the esophagus.
Correct.
Okay.
And our expert Krauss admits that a missed intubation itself is not gross negligence. So just take that off the table. I mean, they say that in their brief. We concede that. What's gross negligence, Justice McCormick, is not to monitor pulse or oxygen content for 12 whole minutes. I mean, just think about the pulse itself, which is about the easiest thing possible.
That's not more negligence. It's now what?
Now it's substantial lack of concern for her well-being.
Well, they were bagging her at the same time. I mean, look, the reason they have the exception is because emergencies are messy, and we want people to try and do the best they can.
We agree.
And we don't want mere negligence in intervention to prevent people from doing these things. And my question is, why does the negligence, assuming that for the sake of this case, that there's at least negligence here, why does this compound to the level of indifference to the well-being of this poor woman?
Because when you've got a person who is in cardiac arrest and who is in imminent danger of brain damage because of their oxygen content, failure to verify and monitor her vitals is a substantial lack of concern, or at a minimum, a reasonable fact finder could reach that conclusion.
I'm still at a loss. I mean, it isn't like they threw her in the back of the emergency vehicle and left her unattended. They were, according to what little I understand of the record, they were continuously attempting to get her heart started and breathing for her.
Sure.
And let's assume for the sake of this, they didn't do her blood oxygen monitoring. Again, maybe negligence. I'm still having difficulty about why that gets elevated to they just didn't care about this woman's
because
health.
It's not a didn't care standard.
Reckless disregard.
It's a lack of concern for whether an injury results. And 12 minutes without vitals meant life or death for Mrs. McLain. If they had taken her pulse and seen that her heart still wasn't beating, one strong reason that might be the case is because she wasn't breathing. If they had been taking her oxygen levels and seen that they were continuing to drop, not going up, and what could they have done about that if they had cared enough to do that? They could have re-intubated her. When she got to the hospital and the doctor's notes established that they re-intubated her, immediately her oxygen levels shot up to 100. Immediately her pulse started. She was entitled to that treatment 10 minutes before it happened.
Can I understand, was failing to take this data gross negligent for so many minutes? Was that gross negligence in your view? Would that have been gross negligence in your view had had the tube still been attached to her trachea, or only because of the possibility that it might have become dislodged?
I think you have to be monitoring for the possibility that it could become dislodged. Keep in mind that when you've got a misintubation and that tube is in the esophagus, even if the person's airway passages would ordinarily be able to open and breathe, say her asthma stopped and so her muscles stopped constricting, that tube would have prevented breathing from taking place. So, the tracheotomies are very common, but the fact that it is so dangerous to the person that you're doing it to requires something more than just, well, let's wait and see when she gets to the hospital. So I don't really think it matters. The failure to verify, the failure to monitor itself is what constitutes gross negligence, or at least, drawing all inferences in our favor, a reasonable fact finder could reach that conclusion.
So it's not just done for the on the basis of a contingency that it might become dislodged?
I think you should do it, yes, absolutely. And we don't know for sure whether it was a misintubation at the time that it happened. The doctor's notes say it's been in there for at least 5 minutes, so maybe it was dislodged on the way. But it's a failure to verify, a failure to monitor, which demonstrates the lack of concern.
But a lack of concern or a substantial disregard for injury? I mean, it's a very high standard, right? I mean, you said it's not. It's not. You quibbled with the Chief Justice's framing of it as doesn't care at all about. But
yeah, I'll just stick with the language in the case law. Substantial lack of concern for whether an injury results. And there are very few cases at this level, well, no cases at this level, very few at the Court of Appeals level. The one that's most analogous is the Sofin case, cited in the defendant's supplemental brief at page 22, note 2. And there, it was a failure to take any action. There was someone who was in obvious medical distress, and the folks who were attending simply didn't take the responsive action that was necessary to do something. This is about as close to that as you can get. Now, I understand, Mr. Chief Justice, that we don't want to jeopardize EMTs and other medical professionals with unnecessary malpractice actions based on simple mistakes or even ordinary negligence. But that's not what this is. When you don't take the two most important vital signs of a person for 12 minutes following an intubation, then you've crossed a line. And if you lower the standard, the substantial lack of concern, too low, then all of a sudden you're immunizing them from conduct that the legislature recognized was actionable. The legislature could have given absolute immunity to EMTs, and they deliberately chose not to do that. I think the Sofin case is the perfect analog for this one. When there's clearly a problem and it's been ignored with the most basic testing tools that you can use, that's gross negligence.
So 12 minutes is gross negligence. How much? Where's that conversion point from just negligence to gross negligence?
I think
is
it would
a
be
matter of time.
I think it would be a fact question on every case. If they waited 1 minute,
in a sense, a jury could find something is not grossly negligent, but there's the very same fact pattern in another case they could find that it is.
Unfortunately, that's what happens with juries all across our state every day. When you're talking about a standard of care like negligence or gross negligence that doesn't have bright lines, it's always fact specific. Sometimes you'll have juries who reach different results.
At what point is it appropriate for a court to make a ruling as a matter of law then? 2 minutes it would have been all right? That as a matter of law that's only negligence? Or maybe
at the point where no reasonable juror could have concluded that there was gross negligence. If it was 1 to 2 minutes, I think a court would be well within its power to say that. 12 minutes, I don't think any court can say that no reasonable person would conclude that's not gross negligence. I'll reserve the balance of my time.
Can I ask you just one more question, please? And maybe this is outside the scope of your expertise, but explain to me what the difference is between the gross negligence standard, which is often articulated in terms of, he just didn't care, with the intentional tort exception to workers' compensation cases, where it seems to be there's got to be a purpose to do harm.
Right. You intended to do harm.
I don't know that I've ever seen a case in which an employer purposely sought to do any harm to employees, so that standard itself has kind of evolved into a he just didn't care kind of standard.
Yeah,
is there a distinction between those?
There is. That's a watering down. Say an employer had an agent that they were responsible for, and they had it out for their co-employee, and so they intentionally took the safety latch off of the bandsaw just as he was about to use it. That would be an intentional tort. Thank you.
Good afternoon. Karen Beach for the defendants, City of Lansing. I'm going to start at the tail end of the argument.
Start by talking louder.
Might help if I raise the podium a little bit. Here we go. As I did highlight in our supplemental brief, there's only been 2 published cases since the Jennings case applying the gross negligence standard in EMSA cases. One of them is this case. The other case is the Costa case from 2004, where the allegations were that the paramedics, quote, failed to assess vital signs, end quote, and failed to even transport the patient to the hospital once they arrived on the scene. And the court found that did not rise to the level of gross negligence. That was ordinary negligence. There's only one unpublished case finding that gross negligence was adequately pled in an EMSA case, and that's the Soffin case that Mr. Bursch talked about. 2 other cases that I highlighted in my brief that were unpublished is the Harrington case, where a failure by paramedics to manage an asthmatic patient's airway, including the failure to confirm tube placement, was not gross negligence. Similarly, in the Castle case, the failure to intubate after noticing the patient stopped breathing was not gross negligence. Here, I don't think we get close to the gross negligence standard. The plaintiff admits that gross negligence is only shown by a complete failure to monitor the decedent's oxygen levels, and oxygen levels aren't only measured in an ambulance EMS setting by a pulse ox or by the other tools that plaintiff's experts said we should have used but weren't available. Both of the EMTs, Murphy and Williams, and the report drafted by them confirmed that the team members visually verified the tube placement in the trachea, there's personal knowledge of that, and monitored for tube misting, chest rise, lung sounds, and the absence of abdominal distension. And plaintiff's expert Krause admitted that he himself would rely on a report of a run done 2 years ago rather
Counsel,
than...
good afternoon and welcome. I'd like you to respond to Mr. Burch's argument. I mean, if we're looking at the gross negligence standard, isn't it in fact the case, and just help me to kind of walk through this a little bit, that we're applying this to EMTs, and I guess the question is that isn't there kind of a baseline of, of service you're supposed to provide, which is what Mr. Burch is talking about, where monitoring oxygen and vitals is kind of like a basic component that takes place in this circumstance? And that to not do that kind of goes beyond negligence and goes to gross negligence, because it kind of, there's like a certain baseline, like a certain thing that you're supposed to do when you're a paramedic, and to violate that would go against the idea of like a basic level of care. And the case that you cite where they didn't transport the person to the hospital, this is distinction because they are transporting the person to the hospital. So don't we have a standard that now takes place once they're in the ambulance heading towards the hospital? Isn't there a certain basic level of care that is required?
Yes, Your Honor. The basic level of care that's required is to assess and verify the tube is properly placed and to continue to assess her vital signs, which was done via checking for tube misting so that the tube was in her trachea, checking for chest rise, checking for lung sounds, and noting the absence of abdominal distension. If this tube was in her stomach for 5 minutes or longer than 5 minutes, the testimony is that her abdomen would have become distended because all of the air from the bagging would have been going into her stomach, and so her stomach would rise. And EMT Murphy testified that if she had had that tube in her stomach for 5 minutes, she would have started vomiting. And at that point, Captain Murphy says, I would have pushed the defendant Williams aside and re-intubated and started redoing this process
myself. But the premise of the question posed was, if the EMTs fail to provide the standard of care, isn't that gross negligence? Is that an accurate statement of what this statute requires?
If the standard of care is that you have to do something to keep this woman alive on the way to the hospital. And so during this 8-minute ambulance ride, the fact that the vital signs were checked only once when they should have been checked twice is not the paramedics doing nothing.
I'm asking a legal question, not a factual question. If there is a standard of care and it's not observed, does that alone establish the standard of gross negligence under this statute?
The standard of care goes to ordinary negligence in a medical malpractice case.
Not gross. So it has to be something more
yes.
than the failure to deliver up to the standard of care. What more must there be in order to establish under the statute gross negligence?
There has to be the willful disregard, the intentional failure to
Doesn't require
care.
Not intentional, that's not, you didn't mean that.
I mean, the failure to care, as Mr. Bursch was saying, the failure to care at all about whether injury resulted to this woman. I don't think the fact that 2 paramedics were working on her for the 8-minute ambulance ride indicated that they didn't care what happened to this woman. And the crux of plaintiff's argument on this point is the testimony of his expert saying simply, well, the paramedic said that he checked for chest sounds, but I don't believe him. The paramedic said that he could visualize the intubation and did visualize it. I don't believe him. That's not enough under the law to rise to make a jury submissible case on gross negligence. We can't just have an expert coming in here and saying that the witness, the source of the foundation.
Making credibility determinations.
Pardon me?
It was testimony of the paramedics, right?
Yes.
And the expert's report was making credibility determinations of that evidence.
It's making credibility determinations without having any other record evidence
I don't care
to
whether
challenge
he
the
did or didn't.
credibility.
If he's saying I don't believe the testimony of the paramedics, that's a credibility challenge.
Yes, that was the expert's credibility challenge. But under Badalamenti, we can't just have an expert who comes in and disparages the sole eyewitness's powers of observation. In that case, we had the expert who said, well, the doctor said he saw this on the echocardiogram, and I just don't believe that. I just don't believe that could be true. And this is what we have in this case. We have the expert saying, well, the paramedic said that he could visualize the intubation, and he put it into the trachea. I just don't believe that's true. And that's why we don't have a jury submissible case on gross negligence. To speak about a couple of the medical issues that Mr. Bursch brought up, the 45% oxygen reading, that's not present anywhere in the record except the note by Dr. Henney, which he testified he doesn't have any personal knowledge of making. So we don't know at what point the decedent's oxygen levels may have been found at 45%. There's not reliable enough evidence of that in the record. And the first arterial blood gas taken after she arrived at the hospital indicated a pH of 7.31, which plaintiff's expert says is normal and not acidotic. And so if the decedent was hypoxic and without oxygen when she arrived to the hospital because of the tube being dislodged for 5 minutes, she would have had an acidotic blood pH, which was not the case. And there's no evidence in the record that the oxygen levels could not have rebounded after a short-term tube displacement rather than a 5-minute tube displacement. And on the failure to check the vital signs, that's based on a 6-person team and not a 3-person team. So I'm not really sure, even if that's what they're hanging their hat on, that that standard even applies in this set of facts.
Which standard is that?
That's the standard that you should check the patient's vital signs every 5 minutes. That's an American Heart Association standard that's based on a 6-person team, not a 3-person team.
Isn't that sensible, though? I'm just trying to we're trying to get a standard. You know, we're trying to understand how this case is going to affect all cases, and I'm trying to understand the standard. Like, isn't that kind of basic? That that's what you do if you're taking someone to the hospital? These are the things that you should just basically do?
Well, paramedics only have 2 hands each, and you've got to keep the gurney steady. You've got to keep the tube in place, which is the important thing in this case, right? You've got a bag. You've got to listen for the lung sounds. There's a lot of things going on in an ambulance where you don't have a whole team like at the hospital to help you. So I think where you have 6 people and 12 hands there available to help, sure, there's someone who can do a pulse ox and take those vital signs every 5 minutes and
but
chart
don't
those.
The vitals kind of dictate? I mean, I totally hear what you're saying, and paramedics do great work. I'm just trying to get a standard. But doesn't the evidence that comes in from those types of checks precipitate the rest of the course of action that you're going to take en route?
It does.
Isn't that your baseline? Like, you have to know that to know what you're going to do next?
The vital signs are not the only means by which you can monitor the patient's condition on the way to the hospital, even with respect to intubation and whether oxygen is getting through, because they're checking that the tube is misting, which means it's in her trachea. They're checking to make sure that her stomach isn't ballooning, which means that it's in her trachea.
But if you don't have oxygen, what's the point of the other things?
Well, and that's the interesting thing that I wanted to bring up about this case is the decedent was in status asthmaticus. It's a very severe asthma attack. And the defense expert and Dr. Kowalczyk testified that the decedent was in bronchospasms for 2 days. That means that even if her lungs would have been receiving oxygen at that time, her I'm probably not saying this right, alveoli and bronchioli were not capable of exchanging the oxygen and carbon dioxide. That's what happens during an asthma attack. So really the interesting thing is that in this case, the woman was having an asthma attack. It didn't matter if there was 100% pure oxygen or no oxygen
So
going through her lungs.
but now your argument is that the oxygen didn't matter. You're not saying, I'm trying to get a standard. You're not saying that the oxygen is important in terms of treatment. Now you're saying in this case it didn't matter.
It did matter, and the oxygen levels did rebound after she was reintubated. That's the evidence. But I think here the trachea placement in the lungs wasn't as important because they were still. The trachea placement was important, but I'm saying that the oxygen wasn't the only way they could monitor the trachea placement. They were monitoring it through the lung sounds, through the tube misting.
You're arguing that they at least were giving a standard of care that wasn't negligent.
Pardon me?
I think your argument is, notwithstanding they didn't use the plaintiff expert's preferred method of monitoring the status of the patient, they were at least administering according to a standard of care that wasn't negligent.
Yes. They were doing something. They weren't sitting back there doing nothing for the short ride to the hospital.
If they were doing nothing, would that be gross negligence?
Yes. It would be. They were sitting, if they opened her mouth, stuck the tube in, and then sat back there on their phones for the hospital ride looking at Facebook, that would be grossly negligent.
Okay, so what if they did the wrong thing?
Well, even the plaintiff's expert admitted that if they had done the tube placement, visualized it, and still done it incorrectly, the mere presence of the tube in the esophagus.
Yeah, but I'm asking you a standard. If they had done the wrong thing, just in a standard. If they had done something completely wrong.
Did the expert testify about that? If they'd done the wrong thing, put it in the esophagus? You were answering. I thought you were.
I'm trying to. I mean, the wrong thing in this case is a range. There were a range in the affidavit of merit of things that they should have been doing to verify the tube placement.
Wrong thing suggests, unless it's done intentionally, negligence, unless it's done with such disregard of the outcome of doing the wrong thing. Correct?
I agree. And the fact that he said he visualized the intubation. He said he did all these steps to check along the way to make sure the tube was in the proper place. That's not gross negligence. If he did them in good faith and they weren't successful.
Why isn't this a jury submissible question?
Because the standard for gross negligence is high, and I think that's apparent in the cases that I cited to you at the beginning of the argument, is that we don't want these emergency medical technicians to feel like if they don't get the tube right every time, they're going to be in court. And I think you can see that even where the facts are kind of similar to this case, that there was a failure to assess vital signs, that there was a failure to take a sick person to the hospital, there was a failure to confirm tube placement or to intubate someone after you saw them stop breathing, that's not been found to be gross negligence, and I don't think there's a need to use this case to revisit that standard. The one thing I want to say about the rules of evidence is that the exceptions to the rule against hearsay, all of them, exist because they have circumstantial guarantees of trustworthiness, which remove the need to have the declarant testify live. And this was in Merrow, where it says the exceptions are justified by the belief that the categories of hearsay covered are necessarily and inherently trustworthy. Exceptions to the rule against hearsay are still subject to the requirement under MRE 602 for lack of personal knowledge, and I just want to point out one thing in Dr. Henney's deposition. Assuming that Dr. Henney was the source of the statement in the medical record, that the tube was found out and that it was for 5 minutes, Dr. Henney says at pages 52 and 53, If he made a statement about the duration of the displacement, it would have been a total guess as to how he calculated that. He said, quote, "I'm completely making an assumption at this point. I don't know. I don't see how that's a sufficient trustworthy foundation to allow the admission of that record into evidence where you have the source, the alleged source of the statement, admitting that he was completely guessing that it was out of the esophagus for 5 minutes, 10 minutes, whatever duration." There's
Thank you.
no further questions.
Chief Justice Young, I think you put your finger on why this is a jury submissible question of gross negligence, because the expert report that we submitted, Krauss, was making credibility determinations based on the medical evidence that was in the admissible documents, specifically the mid-40s oxygen content that was monitored at the hospital before she was reintubated, made him conclude that all these other things they said they were doing in the ambulance didn't happen. Because if her oxygen level was at 45, her stomach or her lungs were not moving up and down, and there wasn't misting in the test tube. And a jury is entitled to disbelieve their testimony that they did everything right. Now, about some of these things that they say, these are all jury submissible facts. That the asthma meant the oxygen didn't matter, that's not true. As soon as that she was reintubated at the hospital, not only did it jump to 100, her heart started to beat again, which was the whole point of this exercise. They needed their hands so that they couldn't slip this oximeter on her finger because they had to keep the gurney in place. It was locked in place, and the tube was locked in place as well. No vomiting if her heart wasn't beating. There would be vomiting if she wasn't breathing. If her heart wasn't beating, that's not true. Every single one of these things are disputed questions of material fact, and a jury is entitled to consider all of them to determine whether there's gross negligence. Finally, just on this question of admissibility, it's about trustworthiness. And there's nothing to indicate that there was nothing trustworthy about all of the medical notes. And even Henny, it's a pretty good guess to say it's out for 5 minutes when someone's oxygen levels are down to 45.
Thank you.
Thank you.
Case is submitted.